Continuing our coverage tonight on the landmark climate change trial, Held v. Montana. To catch you up on this case, a group of young Montanans are signing Article 9 of Montana's Constitution. Section 1 states that the state and each person shall maintain and improve a clean and healthful environment in Montana for present and future generations. Now, those young people believe that the state of Montana is not adhering to the Constitution and has sued the state over this. Ren Wadsworth has been following this story for more than a year now and joins us live in studio with an update. Ren?
John, like you mentioned, this trial dates all the way back to 2020 when it was first filed, but still remains the first case brought by youth arguing against the state on the issue of climate change and its future ramifications for the health of Montanans. In August, Lewis and Clark District Court Judge Kathy Seeley sided with plaintiffs, stating the state failed to prove any compelling governmental interest to uphold the law and are actively contributing to the depletion and degradation of Montana's environment. Following this, the press secretary of the state's attorney general at the time released a statement that the ruling was, quote, absurd but not surprising from a judge who let plaintiffs' attorneys put on a week-long taxpayer-funded publicity stunt. 2 months later, state's lawyers filed an appeal with the Montana Supreme Court regarding Judge Seeley's ruling, reiterating that Montana is not singularly responsible for greenhouse gas emissions, and the state alone cannot remedy harm done to the plaintiffs, one of whom spoke to the judge's initial decision.
Judge Seeley's ruling was really monumental in the sense that it requires the state to consider climate change now, and I think that will have set a precedent for Montana and then hopefully a precedent for the U.S. and globally. I'm hoping it means less smoky summers, more opportunities to go fishing, more opportunities to be outdoors, and really an opportunity for my kids and my grandkids to grow up and live in a world that is as beautiful as it is today and has been for centuries and millennia, honestly.
After more than a year of hearing arguments for and against the ruling, the state Supreme Court moved today in a 6-1 ruling upholding Judge Seeley's support of the Montana youth. The court wrote that the state argues it should not have to address its duty to provide a clean and healthful environment because even if Montana addresses its contribution to climate change, it will still be a problem if the rest of the world has not reduced its emissions. But Supreme Court judges say this argument is too similar to the old fallacy, if everyone else jumped off a bridge, would you do it too? The court decided plaintiffs can enforce their constitutional right to a clean and healthful environment against the state, which they say is owed to the plaintiffs under Montana's Constitution. Following this decision, the Montana Attorney General's office said the decision was again disappointing, but not surprising as they believe justices repeatedly ruled in favor of their allies. And Governor Gianforte released a statement that the court had continued to step outside of its lane. He says that this decision, quote, does nothing more than declare open season on Montana's all-of-the-above approach to energy. An attorney for the plaintiffs say with the ruling solidified, the state will be required to consider environmental consequences caused by greenhouse gas emissions for future fossil fuel permits, marking a pivotal point in Montana's energy policy. We will, of course, continue to follow this case as it develops, but the incoming legislator has already indicated prioritizing judicial reforms in the next session, citing decisions like this. In studio, I'm Ren Wadsworth. Back to you, John.
All right, Ren Wadsworth, there's a lot of good stuff. Thank you very much for that.